Thank you very much, Benjamin. I feel like I'm going to actually be singing here. It's a great honor to, again, speak here at Utah Valley. I've had the great pleasure of speaking here many times since the creation of this center, and to see what Director Rick Griffin has been able to do. Of course, this is an area that has a cultural icon of making things bloom in the desert. But what has happened at the center is really remarkable. It's become an intellectual forum that is second to none. And it brings together speakers from all over the world. And its success is really quite inspiring. And while Director Griffin is not here, this is certainly a testament to his leadership, the leadership of President Holland. The subject I'm going to be speaking on with my colleagues is one that affects all of us in a very fundamental and intimate way as citizens of the United States. It is also a subject that touches directly on the United States House of Representatives versus Burwell, the case that is currently in the courts in which the House of Representatives is suing President Obama for his actions under the ACA, or the health care law. I'm lead counsel in that case, and so I have to be somewhat limited in what I say about the Burwell case, but I will talk about it since it is relevant to this discussion. As many of you know, a few days ago, we won the critical motion in Burwell when Judge Rosemary Collyer recognized that the House of Representatives does have standing to sue the President. It is not the first time that standing has been recognized by the House of Representatives, but it is the first time that a House of Congress has been recognized in this type of case involving the power of the purse. I'll talk a little bit about that later. The most immediate thing that comes to mind when I think of presidential power is not the presidency. It is the citizenry. We are living through what can only be described as a historic period in which we are debating the most fundamental concept of the American Constitution, the separation of powers. I am, in fact, unabashedly a Madisonian. As many of you know, I believe that James Madison was the most brilliant of our framers, and perhaps the most brilliant American thinker that this country has ever produced. But it is fascinating that we have come full circle where we're debating the very foundations of the separation of power, and we're seeing the rise of what I've referred to as an uber presidency, a dominant presidency within our three-branch system. And that would not occur except for a certain crisis of faith. For some reason, I believe that Americans are experiencing a crisis of faith, that we seem to be decoupled from what is occurring within our system of government. To put it simply, our system of government is changing. It's changing in a very fundamental way, and I believe it's changing in a very dangerous way. We've always been bound by a certain covenant of faith. We've agreed to live within the rules of the Constitution with the understanding that we don't always get what we want, but we benefit from that social and constitutional contract. The essential element of that contract is a very simple principle, and the one that animated all of the discussions of the framers of the Constitution, and that is a fear of the concentration of power. It's sometimes called the aggrandizement of power. It is the single consistent principle that guided the structure of the presidency. The framers viewed the concentration of power to be the greatest danger that a free people will face. Now, by the way, it is not true, and sometimes Americans say this, and it's always embarrassing. Once I was introduced in Paris, and I had a leading American politician introduce me by noting that we created the system of separated or divided powers, the tripartite system. And I looked out at this audience of European judges and ambassadors and really wanted to crawl underneath the table. That is not exactly something we could take credit for. Certainly Montesquieu would probably beg to be recognized. What we can take credit for is we made it better. Honestly, I believe that we can't take credit for that. But at the heart of that tripartite system is this anti-aggrandizement idea, that to try to divide the powers of the presidency. I'm working on a book right now and actually just produced a law review piece on the sort of Madisonian view of constitutional interpretation, but I look at it from a different perspective, which I won't bore you by getting into. But one of the things that I have looked at for this work, what I call a con-architectural approach to constitutional interpretation, is I looked at some of the origins of Madison's ideas about the tripartite system. And for that, I found a lot of material at Princeton as well as other sources. And the thing that struck me most is that when you go back to Princeton and take a look at Madison, who really devoured works on government. He was the ultimate geek. He was short, squeaky voice, drove the framers crazy, particularly Morris, I believe, said he was going to throw him out a window if he talked about the Greek states again. What was fascinating is I didn't find any of that. What I found was an enormous amount of work on Newtonian physics. At that time, Newton was the hottest thing around for intellectuals. And Madison was fascinated by it to the point of developing very complex maps of the sort of planets and whole orbital schemes that he saw that met Newtonian principles. And these, I have to tell you, were inspiring in their detail. But what was interesting for me is that when you look at that work at Princeton, you see many of those Newtonian terms and ideas manifest in the Federalist Papers and statements later made by Madison, that he actually incorporated Newtonian ideas. Because Madison viewed the three branches much like three bodies locked in orbit. And he makes continual reference to these sort of bodies and the sort of gravitational pull that keeps them stable, these equal branches. What we're seeing today is the undoing of that work. We are at what I've called a constitutional tipping point. Over the last couple of decades particularly, the presidency of the United States has garnered more and more largely unchecked power. And that has created a shift in gravity in a system that becomes dangerously unstable if you change the balance of power. And so we have the rise of the very thing that the framers wanted to avoid, the concentration of power in a presidency. This was particularly interesting for me recently because I had the honor of speaking at the 800th anniversary of the Magna Carta. And you can always tell the difference between Americans and English speakers, because you'll notice that Sir Christopher refers to Magna Carta, and Americans then add the Magna Carta. And as much as the English try to tell us, you don't need the, for God's sake, we just can't break the habit. And besides, it's one more piece of evidence, as Winston Churchill said, of two people divided by a common language. So what was fascinating about that discussion of the Magna Carta is the more when I was speaking with another esteemed English jurist who spoke before me, is I was very fascinated in how it would all turn out in the United States, because we are debating the very things that underlie the Magna Carta, particularly the question of checking the executive. Now, I do not want to say, and I do not want to be thought to be saying, that President Obama is indistinguishable from King John. For one thing, King John was much, much shorter. But there are similarities in what was being argued 800 years ago and what we are arguing today. Now, of course, when Senator Obama was running for president, one of his main campaign promises was to return the presidency to limited power. He objected to the president circumventing Congress. And that's what led to one of the most baffling moments of my career, when the president gave his State of the Union speech a few years ago and told Congress that he was no longer willing to wait for them to carry out his requests in a host of different areas. And he announced that he would go it alone, that he would be implementing these things that they had refused to enact under his powers as the President of the United States. Now, one would expect that a president who was telling both houses of Congress that he was going to make them a functional nonentity would receive a rather rude reception. Instead, he was met with rapturous applause by members who were applauding their own total invalidity. And I sat there thinking, not only does this border on self-loathing, but maybe, and I rarely will say this, James Madison might have been wrong. Madison believed that self-interest and ambition would protect the balance of powers in the United States. And what we were seeing is a legislative branch, at least 50% of which, was applauding a president at the concept of being utterly circumvented. And the president made good on that promise in a host of areas, on issues like immigration, on the DREAM Act. The Congress refused to enact the DREAM Act. The president effectively enacted it after losing in Congress through executive power. He has done the same in things like the Wire Act with interstate gambling, and he certainly had made dozens of changes on the ACA. And in doing these things, he is not necessarily acting in ways that I find objectionable in terms of the merits. I voted for President Obama. I happen to agree with him in some areas, probably a majority of areas. But that doesn't matter. What he's doing is wrong because the means he is using is wrong. And what he's doing is dangerous. And I believe that what will long haunt the Democratic Party is when they legitimated this aggregation of power in the presidency. Now, obviously, our suit in Burwell deals with one of those areas, which I'm going to mention, but there are about a dozen different areas where the president acted unilaterally. And they include war powers. I represented members of Congress challenging the Libyan war. That case was stopped at standing, the very spot that we have now passed in Burwell. Indeed, a judge at that time said, you really don't represent all the members of the House of Representatives, and that's what troubles me. And so it was fun to come back representing all the members of the House of Representatives, and that appears so far to have been successful. But it is strange of how we got to this point. You know, at the anniversary of the Watergate break-in, I had the honor of speaking at the press club with some of the survivors of Watergate. And my remarks were published in advance, but I didn't actually give that speech because when I stood up and looked out at the audience, I was just overwhelmed. I mean, they're all there. They're all still living, you know, all the people from the Nixon break-in. And I just stared at them, and I put away my speech. I said, you know, I really feel like I have to ask a question that baffles me. I'm standing here looking at all of your faces, and I just want to know, how did Nixon win? I mean, think about it. All of the articles of impeachment against Nixon are now being done openly by President Obama, from the surveillance, from the use of espionage against reporters, from the usurpation of Congress. You can go down the list. And so what has changed? And the answer is obvious. They haven't changed. I mean, the survivors of Watergate, we've changed. The American people have changed. For some reason, we're not as aggrieved. Now, in Burwell, we have the ultimate challenge. In that case, the president attempted to get annual funding for a section called Section 1402 that deals with giving insurers money for the gap between affordable insurance and what they felt was their legitimate profits. And Congress did not appropriate that money and then turned down an annual appropriation from the administration. The administration then, by blog, which as a blogger I find quite exciting, they essentially amended the law by blog. The administration announced on a blog that they would make a series of changes and deadlines. But when it came to this money, the president simply declared that this would be a permanent appropriation, that the money does not require approval of Congress. The result is $6.2 billion a year that is being paid out without an appropriation of Congress. By the way, as I mentioned to Judge Collier in our last hearing, that's actually less than the annual appropriations of the entire judicial branch. Okay? So if you want to look at the size of the money coming out of the Treasury, it funds 1/3 of our government. It is more than that. Ultimately, it will result in $175 billion being paid out of the Treasury without approval of Congress. It is the power of the purse. And that is indeed the mantra that we hear in cases of separation of powers. The courts often refer to Congress not needing standing, not needing access to the courts, because they have the power of the purse. Well, here's an example where that power has been negated. So regardless of what happens in Burwell, the question is much, much more serious than that, even if we prevail in Burwell. The question is what type of system you want for yourselves, what type of system you want for your children. And it is currently a system that is not the one that we inherited. And I often talk about this quote because I think it is the most important quote by any framer in the history of our government. And many of you have heard it. And that is when Benjamin Franklin was leaving the Constitutional Convention, and a woman walked up and said, "Mr. Franklin, what have you wrought? What type of system have you created?" And Benjamin Franklin hesitated and looked at her and said, "It's a republic, madam, if you can keep it." And I always mention that because it is chilling, but it is also the mandate that is handed down generation to generation. It's a republic if you can keep it. And the system of government only lasts so long as you're willing to fight for its preservation, to fulfill that covenant of faith that I talked about. And so I would simply end with this and turn it over to my esteemed colleagues. Presidential interpretation of the Constitution has become a unilateral act. The president has asserted the right to go it alone, and there is no license in the United States to go it alone. You have to compromise. And when the country is divided, less gets done. There's a reason for that. You either have to change the makeup of Congress or you have to compromise. And through that comes that Madisonian value, that the reason we don't have the same violent history of many countries is that we fight between ourselves. We have implosions rather than explosions that occur in Congress. We work it out. When someone circumvents that system, it's not just the usurpation of authority, it's endangering the very thing that has given us the stability that we have had. Thank you very much.